You know, that's really true of a clerk. In fact, when I started practicing law, I had a good friend, still my friend today, who had been a judge for many years. And he gave me this advice. He said, make sure that you become friendly with the court filing clerk. Why? Because these clerks know their way around the courthouse and they know the filing system, and they will work with you if you can garner that kind of relationship with them. So this video is really not about those clerks. Even though those clerks make errors, I want to talk about some things that you can do as a pro se or as a plaintiff to address some issues that might arise between you and the clerk in the court. But then there are those clerks who will break the law. And we're going to look at a case today that demonstrates bad clerks or ineffective clerks. This video is about those clerks. Those of you who have messaged me about this issue, here we go. Be informed, be enlightened, be empowered. Clerks make mistakes. And particularly if that mistake is fixable, whereas it did not cause the plaintiff or pro se any damage, try to work that out with the clerk, with the court. You know, I get messages from many that, for example, the clerk did not file my documents, or the clerk removed documents. Listen, the first thing you want to do to verify whether that is the case is go and review the docket sheet. This is a sample of a review docket sheet. Each time a document is filed with the court, it is listed in this docket sheet by the earliest date to the most current date. The docket text explains what docket was filed. Now, you can review this docket sheet on the electronic case file system, or ECF, or you can contact the court to determine how you can get access to the docket sheet. Now, let me give you a piece of advice here. 1, keep a copy of every document that you file. If you walk to the courthouse and personally file the document, get a stamped copy. Now, listen to this one very carefully. If you mail the document in to get filed, include a self-addressed stamped envelope with a note asking the court to return a stamped copy of your filing to you in the self-addressed stamped envelope that you provided to the court. Okay? And keep a copy of the letter or the note asking the court to provide that document to you. And if for some reason, after reviewing the document, you don't see your filing listed, contact the clerk's office. Don't assume that the clerk or the court is withholding your document. Contact the court and try to find out why the document is not listed. Okay? Now, if the problem is not resolved and you feel like you need to take a more stringent action, you may need to file a grievance. And if you do, follow the jurisdictional or local rules on how to file the grievance. Now, it's important you want to be able to show that you made a good faith effort to resolve the issue before filing the grievance. And remember, always be cordial. I realize that these things can be frustrating. Sometimes they even make you angry. I get it, but it would not be helpful to you. So, when you contact the court, make sure you do it when you're calm, okay? And even if a clerk is negligent, depending on the severity of the case and any resulting damages, let's say damages that are not substantial, work it out with the court. I am sure the court will be inclined to resolve this issue rather than having to face a lawsuit. And quite frankly, the pro se plaintiff should want the same thing. Now, here is where suing a clerk is justified, where a 42 USC 1983 violation has occurred. So let's look at Thad D. Lowe, plaintiff appellant, versus James E. Letzinger et al., defendants appellees. And this is a Seventh Circuit case, 1985. In this case, plaintiff Lowe sued Judge Letzinger, clerk Lukowski, and the Attorney General Pearson. In Lowe's count 2, he alleged that after Judge Letzinger finally issued an order granting him a new trial, the judge, clerk Lukowski, and Attorney General Pearson acted separately and in concert to conceal the judge's order from Lowe for about 3 weeks in retaliation for Lowe petitioning the federal court for a writ of habeas corpus. Lowe seeks compensatory and punitive damages and attorney fees incurred in bringing the prior federal habeas corpus action. And in Lowe's allegation that Lukowski acted separately and in concert with the judge and the attorney general to conceal the entry of the judge's decision, clerk Lukowski filed a motion to dismiss. Now, here is why clerk Lukowski asserted the quasi-judicial immunity defense. Quasi-judicial immunity protects people who perform judicial functions, even if they are not judges. It prevents claims from being made against these people regardless of the merits of the case. In effect, it's an extension of a judge's protection. And we know that judges have immunity, right? But remember, they do not have absolute immunity. And if you recall, I did a video on judicial immunity. And here, Clerk Lukowski is attempting to piggyback on a judge's immunity. So let's go on and see what happened. The district court granted Clerk Lukowski's motion to dismiss. Lowe appealed. The Seventh Circuit Appellate Court reversed the district court's ruling, holding that Clerk Lukowski did not have quasi-judicial immunity. The appellate court held that quasi-judicial immunity does not apply to Clerk Lukowski's alleged involvement in the concealment of the entry of the order because the clerk's duty to type and send notice after entry of judgment is a non-discretionary ministerial task. Now, what is an officer's ministerial duty, and why is this important? Watch this. A non-discretionary ministerial duty refers to a task or responsibility that must be performed, watch this now, by an individual without the ability to exercise personal judgment or discretion. Essentially, it's a duty that requires following established rules and procedures with no room for personal interpretation or choice in how to complete it. Thus, it could be argued that Clerk Lukowski interjected personal bias and prejudice that led to these actions. The appellate court remanded the case for further proceedings consistent with its opinion. And of course, the remand meant that while the court did not rule on the merit of Lowe's claim, it found that Lowe had asserted sufficient facts to survive the defendant's motion to dismiss. And the trial court is required to hear those facts. I trust this has been helpful to you, pro se plaintiff. And as always, I am Advocate Lucinda, and we will see you next time. Take care.